This Honorable Court of Appeals of Tennessee is in session.
Good afternoon and welcome to the afternoon session of the Court of Appeals. Your panel today will be Judge Golden, Judge McGee, and Judge Armstrong. We have anything we need to bring up before we call the case?
No, Your Honor.
All right, you may call the case.
Larry Brown et al. Versus Tennessee Department of Safety and Homeland Security.
Ready for the appellant?
Yes, sir.
You may
Yes.
proceed. Yes, sir.
Members of the court, my name is Herbert Monsieur, a member of the Knox County Bar, and I represent Larry and Shonda Brown in this appeal. I would like to address two issues out of the briefs orally, and I rely on the opening brief and the reply brief of the Browns on matters that I do not discuss. With regard to the two issues that I would like to address, the first is whether the Chancery Court had subject matter jurisdiction over a final decision of the administrative judge with regard to the application of a federal statute, 42 U.S.C. 1988, in awarding attorney fees. The TCA 45314C required for there to be a final decision on that aspect of the Browns claim that the order state the conclusions of law, the policy reasons, therefore, the factual basis, and the public policy. In this case, the administrative judge did not do that with regard to the aspect of the claim for attorney fees under 42 U.S.C. 1988. My adversary, the Department of Safety, claims that the administrative judge was not required to comply with 45314C because the order did not address the aspect of the claim under the federal statute. Respectfully, they're incorrect. The judge did, in his final order issued on September 13th, 2017, at page 3154 of the administrative record, in his final order ruled as follows. This matter comes for consideration of claimant's motion for their respective expenses, including attorney fees, based upon various state and federal statutes. Claimant's motion is denied with the exception of the request pursuant to TCA section 45325. So accordingly, the administrative judge did rule on the claim for attorney fees under the federal statute. However, the administrative judge did not comply with 45314C for the requirements of that order to be a final order, and therefore the Chancery Court did not have subject matter jurisdiction to conduct judicial review pursuant to TCA 45325A.
Let me ask you, why would we remand that back to the administrative law judge? Because we know from reading your brief, that request for attorney fees under 1988 was denied by the administrative law judge. And then after your petition for judicial review was filed, the trial court considered that application and discussed and decided that the administrative law judge was correct and also set out the reasons for that. Knowing that the administrative law judge made a decision that you weren't entitled to them under any federal statute, what would be the purpose of remanding the case to the administrative law judge?
First, so that we could develop, as we said in our briefs, the Chancery Court applied a matter that was not raised by the Department of Safety in its brief or raised below with regard to the application of a parent doctrine. Had we been available before the administrative judge, we would have been able to meet those challenges and discuss before the administrative judge the constitutional violations that occurred.
Did you get an opportunity to do that before the trial court, to make any argument that you wanted regarding whether you were entitled to attorney fees under the federal statutes?
No, because the Chancery Court applied the Parrott Doctrine, which was not raised by the Department of Safety, nor was it raised in any pleadings prior to that time, but was raised sua sponte. So consequently, the Browns did not have the opportunity to meet the pleading requirements or the other requirements that the Chancery Court applied in the Parrott Doctrine. It is our position is, had we had a hearing before the administrative judge, we would have been able to develop those matters further before the administrative judge. We cited a number of pending motions, pending claims before the administrative judge that established constitutional violations that would have met the Parrott Doctrine. However, those were not considered, nor were they ruled on by the administrative judge, because he preempted those analyses under the final order that I just mentioned.
Okay.
I did point out in the supplemental authority the case of Levy versus State Board of Examiners for Speech Pathology and Audiology, wherein the Supreme Court, to a predecessor to Section 45314C, held that the requirements of the rule were not merely technical, but they were absolutely necessary for there to be an administrative review. And once again, because we did not have that opportunity, because the administrative judge did not analyze or rule on the claims that we had presented to the administrative judge, we were denied that ability. I would like to now move to TCA 45325A. 45325A provides that a state agency, in this case the Department of Safety, that issues a citation for the violation of a statute, I'll abbreviate the rule and regulation, that is not well-founded in the law, or not well-founded in fact, is liable for attorney fees to be awarded by the administrative judge. Now, the question or the issue that was, the administrative judge, of course, did award attorney fees under 45325A. The chancellor reversed that ruling, holding as a matter of law, the Department of Safety did not issue a citation for the Browns' violation of a statute. And therefore, since no citation was issued, that section 45325A did not apply to the Department of Safety. Now, with regard to 45325A1, it is important to note that that statute waives sovereign immunity for the Department of Safety for award of attorney fees, where it did issue a citation to the Browns for the violation of a rule, regulation, or a statute. And the citation was not well-grounded in fact, and not warranted by existing law, rule, or regulation. It is our contention that a citation cannot be well-grounded in fact or warranted by existing law, where the facts that were the basis for the citation violated the 4th, 5th, and 14th Amendments to the United States Constitution, as was contended before the administrative judge. Now, the question, however, presented to this court is whether or not a document that was issued to the Browns, a letter, was a citation to the Browns for the violation of a statute within the meaning of 405 through 25A. The chancellor ruled that this was a question of law. And as a matter of law, the Browns weren't issued a citation for the violation of a statute. We submit that the question is actually a question of fact and law, because to answer the question, it is necessary to examine the contents of the document or the letter issued by the Department of Safety to determine whether it contains a citation to the Browns for the violation of a statute. The letter issued to Larry Browns stated that he had an ownership interest in the seized property and cited drug statutes as being the factual and legal basis for the forfeiture of the Browns' ownership interest in the seized property.
Mr. Monsieur, you'll have your rebuttal time.
Oh, have I used my?
Yes, sir.
I'm sorry. Thank you, Judge. I'm sorry, I missed that.
That's all right. All right, we'll hear from the appellee.
Thank you, Your Honor. Mallory Schiller from the Tennessee Attorney General's Office on behalf of the appellee, the Tennessee Department of Safety. The department requests that this court uphold the Chancery Court's order reversing the erroneous award of attorney's fees by the ALJ for three main reasons. First, because the Chancery Court properly exercised subject matter jurisdiction to review the ALJ's order because it was a final order under the UAPA. Second, because the Chancery Court properly found that Section 325 does not permit an award of attorney's fees in this case because the department did not issue a citation in this case. And finally, because the Chancery Court correctly found that there was no basis for an award of fees under 42 U.S.C. Section 1988. Starting with my first point, the ALJ's order was indeed a final order under the UAPA. Now, the Browns argue that it was not a final order because it did not address their argument that they were entitled to attorney's fees under Section 1988. But the ALJ did not need to address that argument because he first addressed the Section 325 argument and awarded fees, albeit erroneously, under that section. Once he had awarded fees under the one statute, there was absolutely no need for him to address fees under Section 1988. That issue was mooted out. It would have been a double recovery to award more fees under another statute. The Browns don't cite to any authority whatsoever that the ALJ was required to address moot issues after it addressed the Section 325 fees. The Browns also point to Tennessee Code annotated Section 45314C, and that language requiring findings of fact and conclusions of law for all aspects of an order. But that's exactly what the ALJ's order had. Section 314C requires findings and conclusions and policy reasons for all aspects of an order, not all aspects of a motion and not all aspects of an argument that a party makes. Again, the doctrine of constitutional avoidance clearly shows that courts don't need to reach every single alternative argument that a party might make in a UAPA appeal. Turning to my second point, the Chancery Court was correct that Section 325 does not permit an award of attorney's fees in this case because there was no citation in this case. As the court is aware, an absolute prerequisite for any award of fees under Section 325 is that the defendant issued a citation. Here, that's simply not the case. Not only did the ALJ not address this threshold inquiry and did not find that a citation was issued in this case, but this court has recently held in the 2018 Groves opinion that a notice of forfeiture warrant letter, like the ones that issue here, is not a citation for purposes of Section 325 and does not support an award.
What is a citation? Tell us how that's different from the letter that was issued by the department.
Well, Your Honor, the statute does not define the term citation. However, in the Groves opinion recognized that whatever a citation might be, a notice of forfeiture warrant letter issued by the department isn't it. And that makes sense in light of the role that the department plays in these administrative forfeiture proceedings most often. Like in this case and like in Groves, it's not to seize the property. Rather, in this case, the seizing agency, the 8th Judicial Drug Task Force, seized the property, gave the Browns notices of seizure, acquired the affidavit of forfeiture warrants and the forfeiture warrants, and then sent all of those things to the department, initiated forfeiture proceedings, at which point the department serves as the administrative forum for forfeiture proceedings. So it doesn't really make any sense to hold that the department is the one issuing any kind of a citation based not only on the Groves holding, but also again on the role, the procedural role that the department plays in these cases.
Who would normally issue a citation? Would that be the seizing officer at the time that these this property is taken?
Yes, Your Honor, to the extent that forfeiture cases involve citation at all, and I'm not certain that they do, but to the extent that they do at all, a notice of seizure would more properly be the citation. But again, administrative forfeiture proceedings really don't involve citations as such. They don't involve, they just involve the seizing agency seizing the property and kicking off these administrative proceedings where, again, then the department serves as the administrative forum.
But the seizing agent is not the department. It's the officer involved in first taking possession of the property. Is that right?
Most often, Your Honor, that's correct. I'm not going to say categorically there could never be a factual scenario otherwise, but certainly in this case and in most cases of which I'm aware, that's correct. And the Chancery Court properly held in this case that the department was not the seizing agency. The department simply wasn't the one that seized this property. It was the 8th Judicial Drug Task Force in this case.
Okay.
So that takes me to my third point, which is that the Chancery Court correctly found that there's no basis for an award of fees under Section 1988 in this case. As the court is, of course, very well aware, Section 1988 only allows for a discretionary award of attorney's fees to prevailing parties in actions to enforce certain enumerated federal civil rights statutes or provisions of the federal Constitution. And it's important to note at the outset that these are aspects of the federal Constitution or of enumerated federal civil rights statutes. Under the authorities that the department cited in its brief, states can create federal constitutional civil rights, nor can they replace federal law on this issue with more favorable law or standards that are easier to meet. So in order to establish that they are entitled to fees under Section 1988, the Browns would first have to have established a federal civil rights claim. They have not done so in this case for multiple reasons. The first one is jurisdictional. As the department explains more fully in its brief, the department just simply is not a person under Section 1988, meaning that you can't bring a Section 1983 claim, against the department and recover. So the department retains sovereign immunity from any constitutional claims in this case. And there's never been any defendant except the department in this case. Second, as the Wimley case makes clear, which the Browns cite repeatedly in their brief, you can only combine a Section 1988 claim for attorney's fees with a UAPA appeal, where the UAPA appeal is enforcing federal civil rights or federal constitutional rights. Here, that's not the case. The UAPA appeal only involved attorney's fees issue. There was no issue of the substantive, due process or Fourth Amendment claims that the Browns allude to in their briefs. And so there's no substantive basis for a 1988 fee. The Chancery Court also correctly found, again, that the department was not the seizing agency and that meant that there could not be a Fourth Amendment claim against the department. Finally, turning to the procedural due process claims under the Fifth and possibly 14th Amendments, the Chancery Court correctly found that The Browns simply never engaged in the necessary analysis to establish federal due process violations, including the Parrott Doctrine. And the department has consistently briefed and has consistently maintained that even if, assuming for the sake of argument, there was some sort of failure of strict compliance with the forfeiture statutes, even assuming that, the Browns have still not bridged the gap between that or anything else in this case and a federal procedural due process violation. And the Parrott Doctrine is the slightly more crystallized, slightly more specific reason why not. The Parrott Doctrine would require the Browns to show either that the established state procedures were themselves unconstitutional and violative of due process, which they've never argued, or that the post-deprivation proceedings were not adequate to compensate them after a random and unauthorized act. But they haven't alleged that either. And indeed, in this case, the Browns received an abundance of procedural due process, which in fact resulted in the return of all of their property. They're simply not entitled to any more process than that. If the court has any questions, I'd be glad to address those. Otherwise, for the reasons discussed, the department respectfully requests that this court affirm the judgment of the Chancery Court reversing the erroneous award of attorney's fees by the ALJ.
Sheila, what about your waiver argument? Because there is no statement of the issues contained in the appellant's notice and brief.
Yes, Your Honor. My understanding was that the court had denied that argument. Certainly, however, if the court were to revisit that ruling, the department would stand by that argument. The rules are very clear on the requirements for a brief, including that the issues be set out clearly and separately. And that was not done in the initial, in the Browns' initial brief, which makes it much more difficult, of course, for both the department and for the court to effectively address the issues in this case.
Was it done?
Has that been amended? Was that amended?
Yes, Your Honor. The Browns filed a supplemental filing, and that included a separate statement of the issues.
Okay.
Anything else? Thank you. Mr. Monsieur, you have 5 minutes for your rebuttal.
Thank you, sir. With regard to the last issue, we did file a motion for the court to permit us to correct the brief. That motion was granted, and we did file a correction to the brief with a statement of the issues, and that was accepted. Going to the question of the application of 42 U.S.C. 1988, we cited the supplemental United States Supreme Court rule in Hutto versus Finley that provides that 1988 attorney fees are payable by a state agency as cost for which state sovereign immunity does not apply. Going back to the 45325 issue and whether or not the letter issued by the Department of Safety to Larry Brown contained a citation to the violation of a statute. The letter, when examined, said, and this is the letter issued by the Department of Safety, the vehicle or other property described on the notice of seizure was seized in accordance with TCA 4033-201 et sec. Upon reasonable belief that said vehicle or other property was used or intended for use to transport or in some manner to facilitate the sale or receipt of controlled substances, or that said property was otherwise used or intended for use in violation of TCA section 5311-451. Now, the panel opinion in Groves that is cited by the parties in this case, and the chancellor in the Browns case, neither of them addressed that provision of the document that was issued by the Department of Safety to the Browns. They did not analyze that provision. nor has the Department of Safety ever, in this case or in any other case, defended against that statement that is incorporated into their letter to the persons who have ownership interest in the property. Now, with regard to whether it was the agency or not, the Department of Safety was required by 45204G, upon receipt of the notice of seizure and the forfeiture warrant and the affidavit for forfeiture warrant, to conduct an independent determination of whether or not there was a factual or legal basis, including the violation of a statute, that justified the forfeiture going forward. If there was not a legal or factual basis found, then the Department of Safety was required to return the property. Now, this independent requirement, State versus Springer said that this requirement required the Department of Safety to anew make those determinations. If they didn't make the determinations, then the seizure stopped. If they did determine that there was a factual and legal basis, as they did in this case, then they went further and they issued this document or this letter to people with an ownership interest, which included the Browns, that charged the violation of drug statutes that they had found through their independent investigation was a legal basis for the statute. So consequently, it was the Department of Safety that made the individual and independent determination that there was a legal basis and a factual basis for the forfeiture of the vehicles based upon the violation of the drug statute stated in its letter. In addition to that, in the letter, the Department of Safety adopted, incorporated, and confirmed the notice of seizure that had been issued by the seizing agency that we spoke of a moment ago. It was part of the notice that was issued to the Browns, and consequently, it was once the Department of Safety determined that it was well-founded in fact and in law as required by 440-33-204G, then it became the continuing seizing agency in this case.
All right, so that's your time.
Yes, sir.
Thank you.
Yes, sir.
We'll do our best to decide this interesting case and get you an opinion as soon as we can.
May I add one other thing to the court? These are petty.
Your time's up, Mr. Monsieur.
Yes,
Thank
sir.
you.
Yes,
Thank
sir.
you. Thank you. All right, y'all are free to leave the Zoom, and we'll adjourn to the next case. Thank you.
Yes, sir.
Thank you.